protections are not absolute. There are exceptions. Employer could take action against the employee where the actions are required by state or federal law. There are some industries regulated in certain ways that might prohibit the use of marijuana. Truck drivers, for example, probably would have limitations on when they can use marijuana under federal law that would have to be analyzed. Employee does not have a right to be impaired by the use of cannabis. So you can't have, or if you have someone who is impaired while at work, then you could take action against them based on the impairment. However, it gets complicated to figure out what impairment is, which I'll get to in a minute. Again, this is pretty much our last topic, so we're just going to wrap this up and take questions. So if you have any, go ahead and start typing those in. The other one is the employer's actions would require such employer to commit any act that would cause the employer to be in violation of a federal law or would result in the loss of a federal contract or federal funding. This is sort of the obligatory throw-in that says, yeah, we realize marijuana is still legal or illegal under federal law. So if federal law forces you to do one thing regarding marijuana, then, we're not saying you can't do it. The real problem with that is there's not very much that federal law requires of employers vis-a-vis marijuana. There are drug testing requirements in the transportation industry that I mentioned that probably would fall into this category. For the most part, I'm not aware of anything else at the federal level that clearly says you can't have employees who smoke marijuana working for you. Let's touch quickly, though, on the impairment question because the law goes further to explain that to be considered impaired by marijuana, the employee has to manifest specific articulable symptoms while working that decrease or lessen the employee's performance of the duties or tasks of the employee's job, position, or such specific articulable symptoms interfere with an employee's obligations to provide a safe and healthy workplace free from recognized hazards as required by state and federal occupational safety and health